Good morning, everyone. Welcome and thanks for being here with us today for our session on Stop, Collaborate, and Listen, How to Prepare for an ICE Visit. I'm Chen and I'm joined by Abtin Bahador. We're both attorneys from Ryan Swanson's immigration group. If you're new to our firm, Ryan Swanson is a full-service law firm based right here in the Pacific Northwest. We partner with business owners and HR professionals, offering practical, creative solutions to safeguard their workforce and operations from potential disruptions. Today's presentation will run about 45 minutes. These are the topics we are looking to cover. All lines are muted, so please drop your questions in the Q&A box below throughout the webinar. We'll tackle as many as we can towards the end. Any questions we miss, we'll follow up with you after the discussion. You'll find the presentation slides and other resources, including a sample response plan, linked in the chat box for easy access. Thanks again for joining us, and let's dive right in.
Thanks, Jen. So, good morning, everyone. We are hearing a lot about ICE in the news as enforcement is a priority for this new administration. If it's any comfort, the amount of arrests per day has not increased over the last administration. We're hearing more about it, and there are reports that they are less targeted in their enforcement than in the past. They've also made mistakes like arresting US citizens. However, they will be held accountable for these mistakes. However, at this point, ICE does not have the resources they need to carry out their grand plans. That said, it is foreseeable that they will try to increase the number of arrests in the coming months if they can build up their resources. The main thing I want to get across to everyone today is that every person physically present inside the United States is covered under the Constitution. No matter their immigration status, the Constitution protects us all. Despite the administration, constitutional protections remain unchanged, and we must vigorously assert those rights. The two protections that we want to highlight today are the Fourth Amendment and the Fifth Amendment. The emphasis on workforce enforcement makes understanding these protections especially important. The Fourth Amendment protects against unreasonable searches and seizures. Searches are physical trespasses on a person, their house, their papers, their effects, so an invasion of something where you have a reasonable expectation of privacy. A seizure is a physical restraint, so a demonstration of authority under which a reasonable person would believe they are not free to leave. In general, the Fourth Amendment requires that state actors, such as ICE, need to obtain a valid judicial warrant to violate these protections. So ICE and other law enforcement need a warrant to enter the private areas of your business, which we'll talk about later. When ICE agents conduct operations without a proper warrant or exceed the authority, you have specific remedies available to you. Additionally, the Fifth Amendment provides people with their due process rights. All individuals, regardless of immigration status, retain due process rights, and these are the ones you see on TV. So the right to remain silent, the right to legal representation, to challenge detention, the right to humane treatment, and the right to have protection against discrimination. These constitutional protections play out during an ICE raid through asserting these rights. So demand to see a judicial warrant, the right to remain silent and not answer questions without an attorney present, the right to refuse an unauthorized search, so if they don't have a warrant, and the right to document any enforcement actions.
So what agencies might be involved in these searches? Who will you see showing up at your business or your organization? Front and center, we have ICE, or Immigration and Customs Enforcement. They are the primary agency responsible for enforcing immigration laws. ICE agents may carry firearms, but they are not police officers. To add to this confusion, you might often see ICE with gear labeled police on it, and then ICE on the other side, or maybe just police or ICE and police. And they might use the name of police to escalate or add pressure to a situation. It's always critical to check who exactly are you talking to. Other than ICE, you have Homeland Security Investigations, HSI. They are a division that focuses on collecting and inspecting employers' I-9 forms and related documents for compliance. Also related to I-9 compliance is the Immigrant and Employee Rights section at the Department of Justice and employees from the Department of Labor. In addition, local, state, and federal agencies are sometimes used by ICE to add legitimacy to a raid or a visit. They still require a judicial warrant for them to conduct search and seizure, or if not a judicial warrant, probable cause. Some states have confirmed that their local and state agencies will collaborate with ICE in enforcement actions, but Washington State is currently not one of them.
And so, what types of enforcement actions can ICE take? ICE typically interacts with businesses either through I-9 audits or unannounced raid. Understanding the differences is crucial for preparing an appropriate response. An I-9 audit begins with a notice of inspection. The notice gives employers 3 business days to produce the documents related to the Form I-9. ICE usually does not demand immediate action, but attorneys should be contacted as soon as possible to prepare your response. Of course, ICE can issue an I-9 audit when they're performing a raid. Raids are unannounced. There's no advance notice and require immediate response by the employer to assert your constitutional rights. Raids typically occur when ICE demands to enter and search a facility. To support a valid raid, ICE should have probable cause to believe an immigration violation is occurring within. Now, if they have probable cause, then agents should arrive with a judicial search warrant. As explained later, the warrant requirement is crucial as it could allow them to access the private areas of your facility. Designating the difference between public areas and private areas of your facility is one of the most important ways employers can prepare for an ICE visit.
So you've been hearing us talk a lot about private and public spaces, judicial warrants. Let's just back it up a little and talk about these terms. First off, can ICE even show up at your location? This really boils down to whether a space is considered public or private by a reasonable person standard. Would a reasonable person feel that this is a place where I can access and I have a right to enter? ICE can enter public spaces and try to engage in enforcement action. However, you always have the right to remain silent. Being in a public area does not give ICE the authority to stop, question, or arrest anyone without a warrant or a probable cause. ICE does not have the right to enter a private space and try to stop or arrest workers or take documents without probable cause or a judicial warrant. Historically sensitive locations such as schools, hospitals, places of worship, and other deemed more sensitive sites were spaces where the federal government elected not to engage in enforcement action. These sensitive spaces are no longer protected by federal policy. In these situations, we would need to look back to the reasonable person test. Is this a public space generally open to everyone? For example, some hospitals, such as emergency rooms, would be considered a public space generally open to everyone due to the emergency nature and how people need to come in without any notice. Other hospitals or clinics might have more stringent entry requirements where the patient has to speak to a buzzer or check in before they're even allowed entry, and these would be considered private spaces. Again, private areas are where you would have a reasonable expectation of privacy, both subjectively and objectively. A private office or area of a facility that is inaccessible to visitors, this is very obviously a private space. The tricky part is when you have one of those like open concept offices or maybe a very large campus where it would deem public most of the times, but there are certain pockets of private space. So it's critical to designate if there is a private space to put up signs saying private, employee access only, personnel access only, or signs that clearly demarcate no entry without authorization. These are things that your agency can do to help help prevent ICE from trying to come in. And also, if they try to come into a private area, it's critical to remind them that this is a private area. Immigration agents can enter a private area only if they have a judicial warrant. So what exactly is a judicial warrant? A judicial warrant is a warrant that's issued by a U.S. court, usually district court, and it has to be signed by a judge. Without a judicial warrant, ICE agents need your permission. So the employer's permission or a permission from somebody who has the authorization to give it to enter private areas of the business. So be careful not to inadvertently give consent. I know all of us want to cooperate sometimes, especially when the situation seems very escalated and heightened. And most people are designed to try to comply. But it's very important to slow down the situation and really think about, am I accidentally giving consent here? Do I have the authority to do so? So it's critical to train and designate an official who is the person who can give consent, and also train your employees on what exactly is a judicial warrant. Again, look at this document here. You can see at the very top, it says United States District Court. And here's another example of a judicial warrant. It should have a signature on the bottom by a judge. Judicial warrants usually are limited in scope and have some aspect of specificity. What is the warrant allowing, and when is the allowed term? Are they allowing search? Are they allowing arrest? Do they have a person designated in terms of who they are looking for? Check the date. Is this actually a stale judicial warrant? Verify that it's signed by a judge and not just somebody who is an administrator. These are all critical aspects that can help protect your company when ICE comes knocking. Sometimes ICE agents will try to enter with what's called an administrative warrant. Administrative warrants are issued by the Department of Homeland Security. These do not authorize ICE agents the authority to enter your private spaces. So again, an administrative warrant doesn't give them the right to actually go into your private space. Only a judicial warrant gives them the authority to do that. Administrative warrants are not from the court. They sometimes say forms I-200 or I-205. They might have these Department of Homeland Security designations on the top. They might say warrant of removal and deportation, Department of Homeland Security. So again, anything that is not produced by a court, anything that's not signed by a judge, it does not give them authorization to enter your private business spaces. Sometimes they might even try to use a notice of inspection. This is a formal request to review I-9 forms within 3 business days. Again, this is not a warrant, and it does not give them the right to enter your spaces. So again, it comes back to designating your public and private spaces. Really consider and look at your business location. If you are a restaurant, for example, and you just have that public nature to the way you conduct business, maybe put up signs where it is clearly private, so that there's a demarcation saying, well, even though the dining area is public, from this point on, it is private only and only for employee access. Have a plan and think about how you're going to treat the space. If it's a very large sprawling campus, for example, and it would be generally considered a public space, if ICE agents show up, is there a representative that can take them to a more secluded location or a certain conference room, classroom, where you can keep them while you're figuring out and contacting the relevant authorities to come and speak to these government agents? Again, mark your spaces, take a look and think it through. Really consider the spatial aspect of how ICE can enter, and it boils down to the reasonable person test. Would a reasonable person feel that I have the right to be here? I have the right to enter. And if they do, then be sure you're checking and asking the right questions about who they are. And then also, if they don't, be sure to train your folks on the distinction between a judicial and an administrative warrant.
So, Jen touched upon it a little bit already, but what should you do if ICE shows up at your door? First and foremost, stay calm, right? You need to train your people to maintain a professional demeanor and ensure that all staff remain composed Panic can escalate tensions and complicate the situations. ICE officers and other law enforcement, they can be on edge, and it's unfortunately on us to keep things calm. So train your workers to breathe, stay calm, do not run to the exits. This will only make things worse for people, as ICE agents will say that if a person is running away, they're obviously violating the immigration laws and must be detained right away. So it's best for employees to stay put and out of sight. If possible, it's best to not allow ICE to enter the building at all and keep your facility private, a private location from the very start. The other important things you can do is take your time. So ICE will make you think that time is of the essence, that they need to get in there now, but they are bound to follow the Constitution, and the Constitution is in place to protect us from the government. And we want to ensure that ICE agents and other law enforcement are following the rules. At this initial outset, you want to gather information and not provide any information. Ask the officers for their name, their badge number, confirm their agency. If ICE, they can sometimes lie. They can say they're just with police. And so it's important to ask follow-up questions about what department they're with. Are you with King County? So, Seattle Police Department? Who are you specifically representing? If they're law enforcement of any kind, ask for a copy of a warrant. Again, don't let them in. They can just as easily slip it in a mail slot, under the door, through a window. If you don't have to let them breach your private areas, that is best. At the outset, you should train your receptionist security to tell ICE that they need to stop and wait and speak to a designated official who has the authority to allow for any further action by ICE. The receptionist, the security should then call that designated official, and it's important to know who that person is. Is it general counsel? Is it an on-site manager? Do not allow anything to happen until that designated official is there. This is the only person that is authorized to review and accept the warrant. The receptionist at this time may call others that need to be there. So maybe outside attorneys, union representatives, maybe civic leaders, right? They should also notify employees and visitors at the facility to stay away from reception. It's up to you if you want to do this publicly or covertly, through a loudspeaker or through emails. It depends on your specific operations. You may also want to assign people, team captains who will notify specific teams and escort those teams to secured areas of the facility that are out of sight from these public areas where ICE could see them. It's important to keep those teams informed of where the search might be happening so that, people don't just wander by and get caught up in it. At this point, once the designated official arrives, it's important to review the warrant. Is it a judicial warrant, administrative, arrest versus search? Is it stale? Confirm that your company's correct legal name is there. Confirm that your address is actually on the warrant and that this is the location that they're allowed to search. The scope of the warrant is critical. Take a photo of the warrant and document its scope and limitations. Send it to your attorneys. Call them and ask questions. Do not just assume that a warrant is valid just because this officer is giving it to you and using their intimidating voice that they're trained to use. So if ICE shows up with an administrative warrant and tells you it's legitimate, even if it has an employee's name on it, that is not enough to search the private areas of your business. You don't even have to say if the employee is working on that day. You don't have to take the ICE agent to the employee named on the warrant if they are at work. It's important to avoid inadvertently giving consent to enter the private areas of your facility, right? So if you are directing them to a conference room, make sure that it is a very secluded area and they're not accessing anything that would be a private area in the meantime. Jen was talking about the warrant requirement. There are some limited exceptions to the warrant requirements, but they are rare. One of the main exceptions is the plain view doctrine. So if the officer is in a public area, anything that they can see is fair game. So it's important to keep people and things out of sight, keep those areas clear of sensitive documents. Another exception is if ICE is in hot pursuit. So if they're chasing someone, the tag rules don't apply here. There is no home base. There is no ollie ollie oxen free. If a person runs into your private area, then ICE could have probable cause to chase that person, right? And then they have access to that private area. So it's important to make sure that your employees don't run away. Another exception is for closely regulated businesses, right? So many places that require an agency license, such as a daycare or a liquor store, right? The government needs access to make sure things are on the up and up. And so ICE can try to piggyback off of these other agencies to gain access to your private areas. Additionally, warrants rely on probable cause. We've been talking a lot about probable cause. What is it? It's reasonably trustworthy information sufficient to warrant a reasonable person to believe an offense was committed. If there is probable cause, then officers can get a warrant. Sometimes ICE or other law enforcement say that evidence or something will be destroyed, will be lost if there is any kind of delay, right? But and so they'll try to use that as a justification for entering now. But courts limit the ability of law enforcement ICE to use this justification because courts don't want to give up power to law enforcement to do as they please. So in general, if there is time to get a warrant, ICE must get a warrant. And that is the general rules that they need to abide by. If they do have a judicial warrant, it's important to monitor the search, right? So assign a designated employee. It could be that designated representative. It could be somebody else to accompany ICE and document all the areas searched and the items seized. Ensure that, and this person needs to ensure that ICE is staying within the scope of the warrant. They should create a detailed record of the entire incident. So time, date, how many agents there were they inside, were they outside, names and badge numbers of everyone there. How were the agents dressed? Were they armed? Did the agents make anyone feel like they could not leave? Did they present proper documentation? Did they do anything that appeared improper? Did they damage property at your facility, right? Did they disrupt your business? Most likely. Did they detain anyone who was a U.S. citizen or a lawful permanent resident? Were they disregarding documents that were being shown to them? It is important to record the interaction, including video recording of the interaction. You can't obstruct or interfere with the search if they have a valid judicial warrant, but you can photograph or record what ICE does at your workplace. If your business has security cameras, ensure that they are in working condition and know whether or not they record audio. Some of them don't, right? You may need to have one of your people record things with their phone. Who feels comfortable doing that? Who has that kind of chutzpah to actually do that? While you do have the right to record enforcement actions, you need to do so openly and without interfering with the agents. You also need to make backup copies of that surveillance footage, store them securely. And so it's important to know how you would access those recordings and where they are actually recorded. These recordings are important as they can prove that agents violated the rights of your business and your workers. I should note that there may be state-by-state issues regarding privacy, but in general, you should be allowed to record people on your private property. Additionally, during the raid, you should take the lead in ensuring all the employees understand that they have rights. So they have the right to remain silent. Don't tell anyone to not answer anything, but just remind them, hey, you have the right to remain silent. Remind them of their right to legal counsel. Remind them that they have the right to refuse to sign documents unless they have an attorney present. They have the right to present valid identification if they have those. Don't help anyone try to escape, but also don't make ICE's job any easier than it needs to be. So don't separate people into Tom, Dick, and Harry are US citizens, and Joe Schmo is not a US citizen, so he goes into that pile. During the ICE raid, it's important to contact legal counsel immediately. Your attorneys can ensure rights are respected, can challenge improper detentions. We can watch things and then file complaints against misconduct, seek remedies for constitutional violations, and just generally protect your business's rights and interests. It's important to keep any documents that ICE provides to you. If ICE arrests any of your workers, you can ask ICE where that person is being taken, and this will help your workers' families and lawyers find the person once they are detained. ICE does have a website. It's locator.ice.gov, where you can search for someone who is in the system after 24 hours, but it's nice to know immediately where that person is going to be. Another thing you can consider is contacting local government officials who may be able to add their, gravitas to the situation and advocate for proper enforcement procedures and protect community rights.
So Abtin touched base a lot on this next slide. Oh, how should you respond if ICE agents attempt to stop, question, detain, or arrest a worker? But we'll do this as a refresher. Never hurts to just, understand the premises of what's happening. First off, always keep calm. Take deep breaths if you need to. Slow down the situation. ICE agents may not stop, question, or even arrest a worker without proper authority or warrant or probable cause, especially if it is in a private location. Staying calm will give ICE agents less reason for probable cause. If you're very nervous, if you start running, for example, as the hot pursuit Abtin was talking about earlier, you're giving the agents a reason to try to catch you. If you are detained, always ask, or if you're being stopped and questioned, always ask, am I free to go? Am I being detained? Is there a warrant? These are critical questions that you should start asking before you initiate a conversation or give them any information about yourself or answer any questions. Again, am I free to go? That is a great question. That should always be one of the first things you start asking. If ICE says you are not free to go, and indeed you are being detained, everyone has the right to remain silent, even if ICE has a warrant. Don't show false documentation. Don't lie, and especially don't lie about being a US citizen if you are not. If an individual has valid immigration documents with them, and these are for folks who are in non-immigrant status, such as H or L or TN, you could show them to the agent. However, that's only if you are carrying them on you. If you don't have them, you should remain silent as well. You can tell the officer, I would like to remain silent. I would like to speak with an attorney. That should be the main thing you tell them, even no matter how many times they try to question you. If the individual does not have documents or is undocumented, they can decline the officer's request, even though the officer may ask more questions. If they escalate the situation, the officer can try to arrest the individual, but the individual you should always invoke your right to remain silent and ask to speak to an attorney. So this is a really critical change in this new administration. Previously, ICE and CBP were only using expedited removal. That's a quick removal process where they can deport someone out of the country for folks who within 100 miles of the border and within 14 days of their arrival. Now the government says it has plans to use expedited removal anywhere in the country, so it's not limited to the 100 miles of the border. Against any undocumented person. So if you are indeed an undocumented individual or you have workers who are undocumented, hopefully you don't know, but if you do, then these folks should carry documents that prove they have been in the US continuously for 2 years before the arrest, because that will protect them from the expedited removal process and give their families more time to seek an attorney. It will give their attorneys more time to try to fight their case. If you are indeed being detained, again, the best way to protect your rights is to stay silent and ask for an attorney. You, as the employer, can remind employees of their rights, saying, hey, everyone, you have the right to stay silent. You have the right to ask for an attorney, but you should not tell people that you need to stay silent because you could be obstructing law enforcement if that happens. So it's very important how you word it. You can't say, hey, Abtin, don't talk to the law enforcement. But you can say, hey, Abtin, just a reminder, you always have the right to stay silent. So it's very critical how the messaging occurs. Workers do not have to hand over any IDs or papers to ICE. You always have this right. Any information a worker gives to ICE can and will probably be used against them later on, especially if that document is damaging. The main takeaways here is that in these situations, keep calm, slow down the situation. First ask, am I being detained? If you want to and you have any questions, because there are additional reports of kind of civilian law enforcement saying, are you with ICE? Which agency are you with? If you are a US citizen, you always have the right to remain silent. If you are a person here in an immigration status, and you happen to have the documents with you, you can show those documents, and that might prevent you from being further hassled by the government. If you don't have them with you, again, you have the right to remain silent and ask for an attorney. If you are undocumented, again, stay silent, ask for an attorney, ideally carry paperwork showing you have been here for over 2 years.
Just quickly, a note on that: if you are undocumented, don't carry anything that shows tied to another country, right? That's it. That's just plain proof that you're not lawfully in the United States potentially, right? So it's almost better to have nothing on you than to have incriminating documents on you. But definitely carry proof that you have been here. So maybe state ID that shows it was issued 2 years ago, as long as it's not, have any kind of citizenship on it.
That's a
Um,
really good point, Abtin. Thank you. And also, for example, if you can't get state ID, some people are even advising a utility bill showing that you've been here for 2 years, or a lease. Any sort of document showing that you have been residing in the US for the past 2 years will be helpful to your case.
exactly. So what actions should your business take after the ICE visit? Um, Review and update your notes after ICE leaves. This would be the time to gather the information, the names and contact information of any witnesses. I would warn against gathering names and contact information while ICE is present, as this could be subject to the plain view doctrine, right? And they could try to gather that information as well. Get statements from witnesses while things are fresh in people's minds, right? Where we're all, you know, we our memories are imperfect, right? And so getting it as close to the time of when it happens is the best you can do. Write it down, get signed statements. Those recordings that we took, make copies of them immediately. Figure out where you're going to send them, right? If you need to email them, WhatsApp them, figure out how you're going to send them to the people that you need to send it to. Debrief with legal counsel. So review all of the documentation from the visit. Talk about how ICE agents were acting. Were they acting improperly? Were they exceeding their authority? You'll probably need to address employees' concerns, right? So communicating appropriate information to your staff while also protecting privacy. Who's going to reach out to the affected families? And having an idea of what support you're willing to provide as an employee. So are you willing to provide leave benefits to affected employees? You can also provide resources to those affected employees and the families, right? This is who you can contact next. You'll also need to prepare to manage external communications, right? Coordinate with your legal counsel on public statements, prepare a response for the media, and then document the economic impact. So keep records of business disruptions, lost revenue, employee absences, customer impact, damages to your reputation, damages to your property. These records may be important for any subsequent legal proceedings or insurance claims. So what can you do now to prepare for an ICE action in the future? The most important thing, I think, is making a written response plan ahead of time. And so, the same way that you have an earthquake drill, right? You have an earthquake response, you should have an ICE response. This should be a detailed plan that outlines roles, responsibilities, rules regarding access to private and public locations, procedures for different type of ICE visits. Is it an I-9? Okay, I-9 inspection, we do this. Are they knocking at the door and trying to get in? We do that. This plan should be readily available to all staff members, and everyone should be kind of trained on it, because one person holding a door open for ICE and saying, "Oh, come on in, Joe," that's the end of your privacy, right? In the plan, you should designate and train key personnel who will be responsible for reviewing the warrants, reaching out to legal counsel, monitoring ICE during the searches, recording the visit, managing these internal and external communications with team members, maybe family members of potentially affected people. Ensure that everyone is aware of the difference between private and public areas. You can also talk to other businesses and business associations in your area. What are they doing to prepare, right? If they have similar facilities, how are they preparing those facilities? And then practice, right? It's just like a fire drill. The more you do it, the more prepared you'll be and know what to say and do if ICE does come to your office.
So moving on, in terms of an I-9 audit, how do you respond and what are the best practices to ensure compliance? Again, as we have been saying repeatedly during this webinar, if there's an I-9 audit, it does not give ICE the authority to enter your location and do a search and try to arrest people. So let them know, yes, you will respond to the audit. The law gives you 3 working days to produce your I-9 forms. You do not have to produce those documents early. You don't get bonus points for producing those documents early. It's best to take your time and review those documents with an attorney before you produce them to the government. You have a right to speak to your lawyer before answering questions or signing any ICE documents. Usually, if it's just a pure I-9 audit, ICE might just provide the notice of inspection and they leave. Don't let them escalate that notice of inspection into something more. Again, don't let them come in. The notice of inspection does not give them authority to enter your private spaces. Review the I-9 and documents for deficiencies, ideally now before you have an audit, but especially during that 3 days. Carefully review whatever you are going to give to the government. Take that time and purge any of those I-9s or unnecessary documents that shouldn't be in there. Make corrections and document these corrections for the record. Almost all I-9s have an error. It's important to recognize and correct it correctly. Don't do it directly on the form. It's usually best to have a memo accompanying it, explaining the situation. I-9 violations have increased in terms of fines. So if it's a paperwork violation, a fine can range from $281 to $2,789 per Form I-9. So if you have multiple employees with multiple I-9s, this can add up really quickly. Document abuse. For example, if you are requiring specific documents, if you are retaining more documents than necessary during the I-9 process, it's $230 to $2,304 per violation. So again, make sure you're keeping your I-9 compliant. That will really help your business in terms of if an audit occurs. After reviewing the I-9 forms, ICE may find some employees who are not authorized to work. If this happens, ICE will give you 10 days to provide valid work authorization for these employees. If you can't provide these documents in that time, you will be told to end the employee's employment. You can always ask ICE for more time. This will give affected workers more time to talk to an immigration lawyer and try to figure out their situation. If ICE gives you a fine, you can always try to negotiate. Bargaining is always involved. Don't take them for the first sticker value that they give you. If the workers belong in a union, you may need to provide copies of the audit documents to the union and work with the union as you respond to the audit. Our colleague Cody Nunn has a great presentation on YouTube titled New Form I-9 and Virtual Document Review Option. Just like to make a plug for that. That's available on YouTube. In there, she goes into more detail about the specific Form I-9 and common errors, as well as what to look out for when you are doing an I-9 audit. So what to do after an ICE raid or an I-9 audit? After an ICE raid or I-9 audit, one or more of your workers may be forced with deportation or unable to return to work. This could impact your business and morale of the workers. It's really important you have a plan in place. Offer leave to affected workers who apply for work authorization, maybe give support in terms of the business's availability and bandwidth. This is an obvious one, but always pay your wages, pay your benefits promptly. Don't try to withhold these. One of the most common reasons for an I-9 audit are complaints made by disgruntled workers. Provide separation pay to workers who cannot return to work. Again, follow the law. As long as you're following the law, usually you shouldn't have anything to worry about. But if you're taking care of your employees and they're not making these complaints, ICE really doesn't have the bandwidth to go specifically looking for you. But that being said, we have seen them target certain industries such as manufacturing and restaurant industries. So make sure, especially if you are in these hot industries, you are keeping your I-9s clean and you make regular audits of the forms. So moving on. Yeah.
Yeah, what steps should you take now to prepare for potential immigration actions? It's simple stuff. So make that written response plan, review your I-9s, find a qualified immigration attorney now before anything happens. Talk to them about your rights, your plans. Provide training to your staff. Provide know your rights training to employees. There's a lot of great resources out there from ACLU and other organizations. There are things known as the red cards, which are available in several languages that are provided by ACLU and these other organizations. And they basically list out a person's rights, the right to remain silent, the right to legal counsel, and a person who does not feel comfortable verbally asserting these rights can just hand this card over to a law enforcement officer, and that card can speak on their behalf, right? It also is a great reminder of what your rights are in the moment, because again, if the person is speaking with their authoritative voice, you might be flustered and forget, well, do I have the right to remain silent? Yeah, here's my card. Talk to my attorney. Train workers not to talk to ICE unless they have to, right? Don't give any information that will harm or prejudice you in the future. Connect with immigration response networks in your area. They can provide resources and support to the families. They can provide legal support, financial support, media support if agents do come to your business.
I do want to say that Ryan Swanson does help with I-9 audits. Please feel free to reach out to us if you would like us to take a look at your I-9s and provide further information. Thank you, everyone.
Thank you.